we are just urging is that there should be full compliance. We are not going beyond the orders of the court. We are very conscious of what those orders of the court were, and we are quite happy with the orders the court had made. So we need compliance in time so that when we come here at 5 o'clock, and remember, my lord, we are only going to be given 10 minutes. So we need also to prepare our responses so that we don't take a lot of time from the courts. So that's all that I wish to say.
Very well. We gave the order yesterday morning. It is for the parties and their agents to work out and comply with the order within the time specified by the court. At 5 o'clock, we want a report. Anybody who will not have complied with the court order will tell us why he has not complied, and we will determine whether or not failure to comply was reasonable. And we will deal with that. Thank you very much, Mr. Ngatia. Can you now proceed? I hope that has not interrupted your train of thought.
It has not. It has not, since Mheshimiwa was one of our candidates in the electoral contest as well.
So Mr. Mwite and Mr. Orengo?
Yes, Mano.
Please communicate with your clients.
Yes.
To what? To comply with the court order.
We have and will continue to do so.
If some of your clients' agents are in Europe or wherever, they must have been told yesterday, wake them up and get the order done, complied with.
My lord, the clients are here in Nairobi. It is their service providers who are in Europe. The orders will be complied with, I assure this court, my lord. But one to point, I think we need to be guided by the IT technical people here. And I think the Supreme Court has its own IT experts working with the registrar of the court, so that this report we also factor in the technical aspects. Because I think when we are talking, we need to be guided by those experts.
Are they not there at the IBC headquarters?
Yes, they are there.
Yes, they will come and tell us. They will come and tell us. Yeah.
That's all I'm asking.
Thank you.
Thank you.
Yes, we have given instructions for more staff.
Thank you.
To be increased at Milimani.
Yes.
So that the work is completed in time.
Thank you.
Thank you. Yes, Mr. Ngatia.
Thank you, my lord. May it please you, my lord. Your ladyship, my lords. Let me start by indicating that we have filed. I rely on the written submission. My lord, it's now afternoon. I'll be assisted by my two learned Segei. Start at the beginning. A presidential election is that an election and it, namely that all registered in that election of this persons registered to vote. Secret ballot. Try and declare the result. Are the precepts, after fights half of victory introduce so from that and your election must be held. Engaging how one is the use the vote and appropriate mechanism. Set out the Constitution my lords who tick complied with. Where with this number 3, it is tick goes to sub-article votes to be half of you A of 4 or the third respondent of the votes cast. Then it must be than 24 held respondent on what the petitioner that was valid. Now, because it's very easy to fall into see if it is a contestation at the High Court on other elections apart from the presidential election. Other elections other than the presidential election, the contestation would be based on in June this year, barely 45 days before the date for the general election. Minor KI is a case that started at the High Court, escalated to the Court of Appeal. At the Court of Appeal, NASA, a political coalition, sought to be enjoined and was enjoined in that appeal. As a matter of fact, I do recall we did not, Jubilee did not participate, but I do recall NASA was represented by, amongst other, my good friend, Senator Orengo. And a 5-judge bench of the Court of Appeal held, amongst other things, that the polling unit is the lowest unit where the poll must be held and a declaration made. That's the first principle of law that is set out in the minor KI case. The polling station. Polling station is where the first declaration of a presidential contest is to be held. The next principle set out is that that document at the polling station is the primary document, and the word used is primary document. Why it is primary, my lord, is so that we can steer away from this contestation about mirror images of that document. Since it is the primary document, if there is any contest about a mirror image, then one must revert to the primary document because it is available. My lords, that case is the one that was, so to speak, the reference point during the last general election. A reference point because it determined for the first time that the votes tallied and declared at those early levels or early tiers in the contest are primary and final. Because they are final, they cannot be altered at the National Tallying Center, and those votes will be taken in their original form as declared at the areas of the electoral contest. My lords, many other cases were litigated. In total, there were about 27 cases, including a case that was adjudicated barely a week before the general election, requiring declaration of results within 7 hours from the conclusion of the contest. There were many cases. The next area I go to, my lord, is the polling date. On the polling date, my lords, it must now be obvious, as I indicated, that all the constitutional requirements were complied with. There is no allegation that elections were not held countrywide. There is no allegation that any Kenyan voter was denied the right to vote. There is no allegation that any region of this country was disallowed to vote. To the converse, my lord, we are in unison, in agreement, that polling was held throughout the Republic and in a very peaceful manner. Now, my lords, and this now I start to engage the petitioners. What we carried out in the polling stations is an electoral contest. And a contest of politics has its own uniqueness. It is not a contest in science. It's a contest in seeking voters from the electorate. So consequently, my lords, the first the Elections Act anticipates that there will be questions about the integrity of the process, and the Elections Act provides for observers to be accredited. Observers to be accredited so that they can ensure or be able to be critically analyze the integrity of the process. Many observers were accredited. My lords, in the affidavit of Davis Shield, we have produced many observers' reports. These reports, my lords, have statutory underpinning. They are required by Section 42 of the Elections Act, and the report must be provided or submitted to IEBC pursuant to Regulation 94, Sub-Regulation 6. So these reports are not without a basis. They have a basis in law, and they are a requirement because it is the first assessment of the electoral contest. And as I keep on referring to this, my lord, it is an electoral contest. My lords, in this affidavit by Davis Shield, we have attached various reports. At handwritten page 4 is the first report by ELOG, Elections Observation Group. On the first page, they say, and there is no dispute, they had 8,300 observers in all the 47 counties. On the page 6, my lord, have in 90 6 failed. I'll go very quickly to page 7. Read the first bullet. Agent representing the in stations where NASA elections. Process a jubilee of all the polling agents signed the declaration of results. 8% of those polling. You see that the two agents signed. We go to the next page. A projection or announced before results are announced was that Uhuru Kenyatta he had of their projection. The 4.9%, very near to the an electoral contest are able issues of integrity and report that is one fair and credible. In 2017, page 30, based on his observations in this supplement, election a true reflection I am looking at page 31. Process at the polling station transparent and proceeds staff of IABC and all the security personnel for efficient in the conduct of a peaceful and another tick. It was trace in a second. Peaceful manner, there were no riots, there was no commotion anywhere, and that is not an allegation before you. We are in agreement that we are peaceful voters. Based on those observers' reports, our integrity in this electoral contest, my lord, wholesome approach hold that a process that was credible. A moment ago, my lords, I indicated to you when you have time in the complaint. Let me deal with that complaint because it's important I deal with it. It is true, my lords, that the first result that streamed was at 507 from a polling station where the first petitioner had 6 votes and the third respondent had 4 votes. So the votes cast in that polling station were 10. 10 only. And there's no argument that they were only 10. But the argument is it was very quick for those results to stream in. My lords, how long does it require to count 10 ballot papers in the presence of agents? You hold 1, 2, to count 10, my lords. We do not want to waste your time. Would be something towards 2 minutes, if not less. So for results to stream at 5:07, it's a polling station. Narok is from a prison, Narok main prison. The next stream was at 5:08. Where the first petitioner had 9 votes, the third responded 3 votes. So total votes 12. And I would only give 3 more. The third was 509. First petitioner had 5. Third respondent had 7. And all the timesheets are before you, my lords. And then we go to 512. Petitioner had 3. Third respondent had 43. And finally, 514, where petitioner had 42, third respondent had 3. My lords will see that those were polling stations, and their polling stations, all the timesheets are before you, and these, they will be found in the affidavit of Davis Shishil, who was the chief presidential agent. And those are documents, my lords, that all chief agents were given access to, and every party agent had access and was given copies of all these. From that analysis, I request, my lords, to make the following deductions. First, that polling stations did not necessarily have 700 voters as submitted by one of my learned friends. And number 2, that formula that was displayed before you for a long time with a mathematical basis which is unknown to any other person other than the author of it has no application. Because from these results, one can be able to see that all these candidates are getting votes from polling stations in a manner peculiar to that polling station. There was no mathematical predetermined way of voting in the contest, and there can't be. As a matter of fact, even going by the declared results, one will see not a difference of 11%, which persisted even yesterday. I would have expected really by a process of deduction that one will see, you cannot say 53 against 44 cannot be 11%. My lords, I will be turning to those arithmetic in a little while. But that mathematical formula has absolutely no application whatsoever. My lords, the streaming in of the results was as a consequence to the process that had already been started of having a very free and fair election, and an election which was conducted peacefully, and counting and tallying of votes started taking place immediately after 5 p.m. My lords, I dealt with the observers' reports. I went to the streaming. It will be a good point for me to indicate that we have a video of one of the persons who participated as an observer, and it will be important, my lords, for you to hear what he said about our elections. This is Mr. Kelly, who was a candidate in 2004 as a Democratic Party candidate in the United States of America. Having been a presidential candidate And having participated as an observer in our elections, his views, I would submit, would have a bearing on what took place. Hey, time.
About Odinga's comments that the results of the election are fake and factitious, about these allegations that certain voting machines were defunct. How do you respond?
We think that the open process we witnessed, where every party agent was present, where they all agreed on what a disqualified ballot was, what a qualified ballot was. They were present when the ballots were open, present when they were closed. They even were asked, do you agree with the final tally? And after there was all agreement, the tally was sent in on what is called this 34A document. So there is a way to go back. If anything was changed, if anything was electronically fiddled with, there is a way to go back and absolutely ascertain what happened in the polling station. So by paper ballots, there is a protection of each and every Kenyan's vote. And I think it is important to let the process work through so that the Election Commission has a chance to show Kenyans the way in which they have held to the rules and, in fact, implemented an election that is accountable.
So given what you observed and what you've just said, what do you make then of Mr. Odinga's comments?
Well, I'm not going to characterize any candidate's comments at this point in time. You know, he is a candidate for president of Kenya. He has a right to question certain things. But I also think he obviously has a responsibility to Kenya, to the democratic process, to the rule of law, to make certain that he is providing the evidence and going through the legitimate judicial process that is there for examining any kind of concerns that anybody has. Every observer group is asking for all of the leaders to be responsible, to allow the process to work out, and to put to test the system that has been put in place where transparently and accountably to everybody, in the full light of day, people will be able to see what happened on a particular ballot in a particular balloting location and examine whether or not the process was properly followed.
We are hearing of some protests yesterday. 2 people have been killed so far. Are you concerned about this violence?
Well, all violence is unacceptable. And of course, anybody is concerned, anybody in their right mind is concerned about the potential of violence getting in the way of the legitimacy of this process. This is not an electronic vote, ultimately. It's a paper ballot vote. And so it is determinable as to what happened. And I think it is important for all of the candidates to allow the process to be transparently put to the test, and then if they have a concern, go through the rule of law, go to the court process, and let the evidence be there for everybody to see. I think there is great legitimacy is, did everybody follow it? And has it in fact, it's their individual votes that they weighted or believes, and the other, we can determine whether or not those votes and whether or not the intention and every
from my lords would have observed over 400 integrity of constitutional requirements. Percentage of the in the e-log report is over, and very important, my lords, if there's 4A 1A, because as a contest, if any, those numbers can only speak one voice. On questions of transmission, because across the board, because what they are doing is litigating the rights of Kenyans, not this infractions at municipal law level in advance before you. My lords, going through the affidavit of Dr. Oduo, those grievances can be group number contentions is he is increased one vote, and he took that a whole signed by agents make anything about it. A very that the election can take place. Let me now take the hint. Fact. May I to winning good edged numeric. Very well. It is one the of those numerical with the first one so that I can we have dealt with the paragraph not indicated. It's indicated 50. 56 votes in Form 34. We have that was reduced to 54 is a false statement of fact. And then we have dealt with it all the way to the end. The petitioner is the third one. From all the discrepancies, each one votes. From all the discrepancies, 822 votes. Then the third respondent is the candidate with 974. Again, from all the discrepancies, the third respondent's vote tally would reduce 74 votes. Is my lord with me? Hence, my lords, from all those so-called discrepancies, the end result is, and I use my lords, in the fullness of where it is a true allegation, my lord, we have tabulated that which the irregularities. My lords, discrepancies no. Hand in hand with numerical discrepancies documents themselves. Last one. The big, because that's the summary. In paragraph A is uploaded. In Mombasa, document. In the first C, the 9, page 10, handwritten page 4. Next one is that those. Why have we gone to this extent of this listen to this presented all the evidence before the court. Reflect, have a self-referential moment. Theory anymore. Silence. Insignificant. The results that were declared that the third had 50 out of the 15 point something million votes. I say approximately because there will be a few thousands and a few hundreds. Because it will be easier. A difference of 1.4 million is significant. It is a difference that shows the will of the Kenyan electorate. And when one compares with the numerical differences which have been brought before you of 800 votes, then those numerical differences can only be said to be quite insignificant. That is not to say that we for one moment countenance even a single vote being taken from the first petitioner to the ballot of any other person. We do not. But we appreciate that is our fellow brothers and sisters who are doing this tallying process in very difficult circumstances. Circumstances which have received judicial recognition in our courts. Kenyans want the outcome immediately. The clerks have been working the entire night and the entire day. So errors of addition may arise. But it is an electoral contest. It's not surgery in theater. While liars, we have demonstrated that our worthy opponent votes tally 800 were deducted by error. What must be said, my lords, and I want to say it as humbly and as firmly as I can, that was not at the instance of the third respondent. He had nothing to gain from an extra 800 votes. He would not even countenance such an error, but we accept. As a matter of fact, if a similar exercise was carried out for the third respondent, and we have carried it out, we lost about 2,000 votes. Some posted to the candidate just next to us. A place where my client had 100 votes is posted to Wainaina. And Wainaina had 0 vote is posted to my client. And those things do happen. At the end of it all, my lords, one is looking at the greater good of the process instead of what is scientifically a scientific impossibility. My lords, I move to the next point, which is a complaint on rejected votes. I would wish to associate myself with the submissions made by Ahmed Nasil. Those rejected votes have been analyzed in a similar exercise as we have analyzed, and the analysis will be in the affidavit of Mr. Davis Shishil. The rejected votes at the last presidential election was approximately 81,000. It is our submissions that rejected votes cannot be taken into account in the final tally. It was a point that we argued in 2013. Nothing has changed since then to warrant a departure from the judgment that this honorable court made. Apart from the principle of stare decisis, there is a greater principle that in these electoral contests, which is nothing more than a political contest being now brought to court, that there should be a fair degree of predictability, a fair degree of uniformity in the judgments from the court, so that our political players do not all the time seek a departure from what has been decided previously. My lords, the next point I would wish to deal with is about polling stations without adequate coverage. The coverage was either 3G or 4G. My lords, prior to the polling date, my lords, it is common ground that political parties were informed, and Kenyans too were informed, about 11,000 polling stations which did not have adequate 3G or 4G network. And they were informed that the results from those polling stations will not be streamed as instantaneously, or the images from those areas will not be streamed as instantaneously as the polling stations where there was adequate coverage. My lords, we must accept one thing, that these telecommunication players do go where there is good business for them. So in places where there isn't a lot of our brothers and sisters, they may not find it very lucrative to invest a lot of infrastructure. So there are indeed places in Kenya without 3G or 4G network. In those areas, my lords, it's not that the voters were disenfranchised. On the contrary, voting took place. The votes cast in those places are captured in the affidavit of Davis Shilshil, and in total, 3.5 million voters much of value and weight a legitimate argument about the voting on those areas. All of for it a little, my lord. Even in the video by 20,800. 883. That this is a different because why not go to the original form? It's not tally. Next point, which is, I say about this, the better voting did take place. Polling station the large numbers of their own, and that can validate I have done although threatened so that they could all vote for him. Has been there who is the principal secretary to up to 20. It is intelligence reports in that area. And they were campaigning for a political party, which is NASA. And he passed that communication or that. And when the third all public officers in very general terms that none should campaign for anybody, and not even himself. And when politicians take to the microphone and say, look, people less engaged will be here, this country is larger than all of us, let's not do politics. The results in that area, my lord, tell the truth. One could look at the antithesis of the hypothesis that was put forward. First, petitioner garnered 301,000 votes from Makueni. 301,000 votes. A paltry 27,000 votes. A small decimal of what the first petitioner received. So where is this intimidation? It is disproved by the results at the poll. It is disproved by the fact that no chief has ever been terminated from employment. It's therefore unfair, my lords, quite unfair, for an accusation of that magnitude to be made, directed at another political player, that you intimidated persons or intimidated public officers, whereas the opposite is there. The opposite is the true position. Still with the affidavit of the principal secretary, the next accusation is that the third respondent went to Kisii and Nyamira talked to the IDPs in those regions and bribed them to vote for him. Those allegations, my lords, have been denied by Mr. Kibisho in his affidavit, starting from paragraph 6 all the way to paragraph 19, in which he deposed, my lords, and this cannot be denied, that this difficulty of IDPs started after the post-election violence of 2008. Successive governments have tried to resettle the victims. The current government in office, in its own budget, provided funds for the persons who had not been resettled. That budgetary provision, my lords, and this is quite important, received approval from the National Assembly. These are not funds taken away from somebody's pocket. It's the National Assembly that approved that budget. And as a continuous process, IDPs are resettled throughout the country. And the resettlement of IDPs in Kenya is within a body that is defined to in the affidavit, and which is known as the National Consultative Coordination Committee. It is that body that disburses funds to the victims. National Consultative Coordination Committee gets funds. The funds are approved by National Assembly, and they are no evidence before IDPs also in the beneficiaries what she received. Coordination Committee. Not as accusation there is aspect to do with established altar, so to speak, in statement that is specific. We shall make no, I understand. This case is it's bench division. Rahman, inducement of the vote and must be Secretary Mushero in government. I start off by making this submission that allegation is not in the petition. The petitioner was presenting their case. Mushero was never served with that affidavit, and within the limited period that we had, we were able to prepare, file and serve an affidavit by Mr. Shishil, court stamped 28th August 2017. It is not alleged, my lords, that Mr. Mushero was campaigning for any party. What is alleged is that he was interviewed and he said he is entitled. Yes, he said he is entitled to campaign. So the allegation is based on an answer to a question. And surely an offense cannot be made, or the answer cannot be the charge sheet of an accusation of such magnitude. Mr. Mushero indicated his view about political neutrality, and citing Leadership and Integrity Act, he indicated that as a CS, he is entitled to participate in the affairs of government, including making such campaigns or advancing government policy as necessary. So, my lords, in my submission, that complaint falls flat on its feet because it is ill-founded. The next one is about CS Eugene Wamalwa and Mwangi Kionjori. I'll deal with them all at the same time, and Kazungu and Barara. All those allegations came yesterday in the affidavit that was filed, and those named persons were given no opportunity to respond to any evidentiary material that was presented. And I say this once again, those are not accusations or allegations that are in the petition. Those four persons, their names are nowhere in the petition. The petition. In the petition, my lords, after dealing with all the municipal law issues, the only reference to the third respondent, I'll get it in a moment, 31. The only reference to the third respondent is in paragraph 31. And the one that would be more pertinent to this would be 32, which reads, no, petition, yes. Petition, with impunity, I read, with impunity, the third respondent contravened the rule of law and the principles of conduct of a free and fair election through the use of intimidation, coercion of public officers, and improper influence of voters. No reference to any person. This is very generic, imprecise, without any particulars, and at most refers to public officers. The cabinet secretaries cannot be called public officers. They are state officers. My lords, one cannot make such a generalized allegation. At the tail end of the petition, now so to speak, drop in names of persons and give them no opportunity to give a response to those accusations. I will therefore request, my lords, to hold and find that all those allegations against the cabinet secretaries are without any foundation and to dismiss them. There is such a fundamental distinction between the public officers and their role and state officers. I have dealt, my lords, I hope, with quite a number of all the allegations against the third respondent, but I will deal with a few more because of the prejudicial effect they have or they may have on the mind of the court. Substantial time, my lords, was expended on transmission of votes. So I take that as another subheading. Amended the Elections Act that elections should be held. Voter identity kit. The complementary given to the voter. Is manually and all the process and including the 4A, all that was 34. Now see the rationale of it. Constituency agents are end of the day at every polling station. Magic in the electronic transmission is the results. There was any failure, but even the ultimately to be stretching logic to an point, then those results are to hold that although there was no failure in transmission basis to invalidate constitutionally compliant with election. Are two positions of what I will refer put it very another elect 60 days. My lords, months will be political climate or manner. It will engage. Contest is held. If it is a reality, to the two, let me speak for from me whether I need but no, that is taken in not to go to that, but contest. It represents that this nation election, with all the invasive aspects of a presidential election. My Lord, like we are advancing the rule of law. We are not really here advancing the rule of law. We are advancing an opportunity for an electoral contest. The other reality presented by the third respondent is this, my Lord. To allow the third respondent move on with constituting a government, he has offered a hand of fellowship to the petitioner, offered a hand of fellowship to all Kenyans that it is time to go back to nation building of this great nation. I paraphrase without the eloquence of the third respondent that the time of elections are over. Let us go back to building this nation. If given that opportunity by this noble court, what I look for or look forward to is an inclusive government where each and all Kenyans will be participants. That is the reality that I'll urge this honorable court to find favor with, because we cannot be in an electoral mode throughout our lives. There is no guarantee, my lords, absolutely none, that even if we were to hold another round of elections, those minuscule errors or by clerks will not take place. They will still take place. but those errors are so insignificant that they do not affect the result of any outcome. I conclude my submissions. Yes, I am told by my assistants, my lords, that as regards there was a complaint about there being such a big difference between the people who voted for in presidential elections as compared to people who voted for the other elections. Before we play the video, let me say this, that we have in the affidavit of Davis Shishil demonstrated that there are indeed peculiar Kenyan habits even in voting. In certain areas, and we have identified 94 areas, you will find that the outcome at one election was so high as compared to all the others. And that is nothing more than that the people in that area were, in all probability, voting for one candidate who was their favorite candidate. Say, for example, a member of parliament may get more votes in that area, more than even the governor or the president. Which one? The presidential. Number two, before we play the video, is to show, my lords, that if you compare Jubilee Party election results for the post of governor or the post of senator or woman rep, members of parliament, you see that in all of them, the results are in the region of 53 to 60%. 53 to 60%. Play? Okay. Now we'll show a short clip and then I'll be concluding. Yes, it won't take long. Okay.
So for the presidential, that is what we have. Our client had 54.3%. Then we go down to the gubernatorial. He had 53.2%. And the next one is now the pattern. The one marked red represents Jubilee. We can see that it is more than half of the map of Kenya. And that explains the number of governors. Jubilee has 25 seats. We have KANU, which is an affiliate party, which has 1. That takes it to 26 seats. Way down to the Senate election results, we find that Jubilee Party has got 51.1%. The Senate election results, Jubilee, the voting pattern is as shaded, representing the 51%. Parliamentary election results, we find that the Jubilee Party has 48.6%, together with other affiliated parties as shown. Then we go to that is the total number of the positions. We go to the women representative. At the women representative, we have Jubilee having 55.3%. The voting pattern is shown. Then finally, that is it. Thank you. Thank you.
So, my lords, from all those results, and these are 6 elections held the same day, you will see, my lords, that the result for the president is not dissimilar, and that is the point I wanted to make, is not dissimilar from the results in the other 5 elections. As a matter of fact, one would say they all follow within the same range. So there are any aspects about votes being added, votes being deducted, it's really not scientific, it has no basis, and it's yet another allegation, which is a red herring. I therefore conclude, my lords. I started from a constitutional argument point of view because in my submission, a contest regarding presidential petition or presidential outcome ought to be litigated within the confines of the Constitution at the very least, or bearing those articles in mind at all times. And in my submission, the quantitative test is at the highest level. Highest in the sense that one must gain not less than 1/2 of the votes cast. That is unique to the presidential results. It's not similar to the other 5 results. In the other results, actually one who has even 21% or 20% or whatever percent could be declared the winner. Number 2, my lords, having demonstrated that elections were held within the expectation of the Constitution, it will be unfair in my submission to invalidate them for infractions, which infractions we have demonstrated do not exist. And finally, my lords, that as regards the accusations against state officers, those allegations are without any basis whatsoever. They were not pleaded in the petition, and they cannot be, so to speak, added at the tail end of the hearing of this petition. My lords, my learned friend, Mr. Ahmed Nasir, will now conclude all the submissions that we have made.
My Lord Chief Justice and Judge of the Supreme Court, I think one document we should have really highlighted right from the start, but we didn't do, was the affidavit, my Lord, by the 3rd respondent. And I would just like, very briefly, my Lord, just to refer you to paragraph 7. So that gives you the best image, and it's a pretty image. It's the best, but so that, my Lord, it gives you an image of how sweeping the victory of both the 3rd respondent, his party was in all the 6 elections. And my Lord, if you look at paragraph 7, you can see page 2, everything red belongs to the 3rd respondent. If you turn the next page, my learned friend has shown you the video, but this one provides a better picture so that you can really see how sweeping it is. If you look at page 3, my Lord, it is the governors. Then you can see the Senate again in red at page 4. Then you can see women representative. It is slightly even more when you come to women in time of how Jubilee was women friendly. And then at page 6, my Lord, is the National Assembly, my Lord. So, my Lord, I think that's the point my learned friend emphasized, that there was nothing ordinary. It was not a case where the respondent wins the presidential election and he has 10 members of parliament. No. I mean, my Lord, Jubilee has the largest number of a single party since multi-party democracy was introduced in 1992. Its victory was that sweeping. My Lord, My Lord, there is an issue raised by the petitioner in relation to Section 83 of the Election Act, the one that talks about non-compliance with the law, which says, my Lord, that no election shall be declared void by any reason of non-compliance with any written law, as long as that non-compliance, as long as the election was conducted in accordance with the principles laid down in the Constitution. And I'm emphasizing the principles laid down in the Constitution. My Lord, Chief Justice, it's not in dispute that when it comes to a presidential election, the constitutional regime that regulates a presidential election is very distinct and defined in the Constitution. And my learned friend rightly emphasized that point. And my Lord, the constitutional regime for how a presidential election is conducted is found in Article 138. So, my Lord, the principles referred to in Section 83 of the Election Acts are those principles that are captured in Article 138. And what are those? There are 4 principles, my Lord. 1, all registered voters must have an opportunity to vote, or all those who are entitled to vote. Secondly, my Lord, is that secret ballot. The election must be secret ballot. That's the principle. For example, if the election was Mololongo, or if there were law instead of a secret ballot, it will be in breach of the constitutional principles. The third one, my Lord, is that the votes must be counted in the polling stations, and IEBC shall tally and verify and count the result and declare. And lastly, the candidate shall be elected president when he wins 50+1. Those are the constitutional principles, my Lord, that Section 83 envisage or holds to in a presidential election. My Lord, the other point is, and I think my learned friends for IEBC captured it very well, is that this allegation of disparity between the presidential election, in other words, more people voted for the president than other candidates. And my lords and my lady, I will just very briefly draw your kind attention to the affidavit of Winnie Guchu. And my lord, if you look at page 36 or paragraph 88 of that affidavit, we analyze 94 constituencies where other positions other than the president got the highest vote. And even in Kiambu itself, in several constituencies, the voters gave more votes to the women representative than the president himself. And we have given the list in paragraph 88. Even in my learned friend's constituency, he got more votes. The governor was the most competitive seat. So it depends from one region to another. There are certain places, for example, where if you look at that page 36, Kibwezi East, the senator was the most competitive. If you look at Voi, the senator was the most competitive. If you look at Molo, the parliamentary seat was the most competitive. If you look at Rongo, the governor was the most competitive. So, my lord, as they say, all politics is local. That is what determined which was the most competitive. Lastly, but not the least, if you look at the Stare, the woman representative was the most competitive seat in that election.
Mr. Nasir, if I understand the argument well, is that the votes cast, the total votes cast for the president were more than those cast for the governors, for example, for the women representative, for example. It's not a question of a president getting more than the governor or what?
We have done the total, my lord. Yes. But, and I think IEBC, Mr. Somane, explained it very well. But even when you do that, it's not necessarily true, or the difference was very insignificant. My learned friend will explain that quickly. But my lord, finally, it's my submission, my lord, that the petitioners have not discharged the burden of proof. That burden, my Lord, because it has not been discharged, at no point during this trial did that burden shift to the third respondent. But my Lord, that notwithstanding, and out of abundant caution, that suspender and belt approach, my learned friend has taken you through each and every allegation they have made, not to prove, but to show, my Lord, that all those allegations were false, whether it's in relation to uncasetted polling station, whether it is in relation to the disparity between the presidential and electoral offices, and, my Lord, any other averments that's contained in the petition. So, my Lords, it's the prayer of the third respondent that, in light of the failure on the part of the petitioners to discharge the burden of proof, this petition should be dismissed with cost. And I pray that it be satisfied for two counsel.
My Lord, we would always spend just a few of our time. One is to answer, my Lord Chief Justice. There is no legal obligation on any voter to vote in all the 6 elections. True enough, you are given 6 ballots. You are given 6 ballots, but there is no corresponding obligation that you must vote for all the 6. So you see, in certain areas, and we have done a mathematical analysis, in certain areas you find almost a huge number of people voted for president and, say, senator, and for governor there was very little voting. And those are some peculiar habits of our voters. Yes. So in absence of a legal obligation, so there are some ballots really that do not count. My Lords, there is an issue that was raised by Senior Counsel Mr. Orengo yesterday, Senator Orengo, about barcodes, that some documents don't have a barcode. I had not anticipated that in the written submissions. Allow me to answer it in these submissions because it wasn't in their written submissions, about absence of barcode in certain of the forms.
Mr. Ngata, just before you leave the question that voter is not obliged to vote for the 6th candidate.
Yes.
That is the position.
Sorry?
That will not be the position.
About a legal obligation.
A voter can vote for one candidate and not for the others. That's what you've told us.
Meaning a comparing obligation that you must tick. You are given the 6 ballots, you are given a place to go and vote, and since there isn't a comparing force, that's what I meant.
You're saying the same thing?
Oh, very good. Thank you.
My question is,
yes,
how are the other ballot papers accounted for? Because at the point of getting the ballot paper, a voter gets 6, correct?
Yes.
And they choose to vote for MCA and not for anybody else, right?
True.
So what is the name given to the other ballot papers? For the president, is it spelled? Is it straight?
Yes.
Is it rejected? What is it?
I wanted to handle those two, or one of my colleagues to handle those two together. That's why I was explaining the point, the point of the barcode raised by Senator Orengo and the question by my Lord Chief Justice, and invite one of my colleagues, Mr. Masharia, to answer both within a relatively short period of time.
Thank you very much, my lords and my lady. I deal first with the question of the barcode that was raised. And the first... I deal first with the question of the barcode. The barcode was not an issue raised in the petition to begin with, but having been raised, this is the explanation. Number one, the format of the forms prescribed under the election general regulations does not require a barcode. The format of that particular form, that's number one. Secondly, that barcode, as we are made to understand, was limited to Form 34B. Thirdly, it was not in the prescribed requirements that the IBC sent to the printer. It was an innovation originating from the printer themselves as surplusage. That's number three. Number 4, the question was one, and this was dealt with at the scrutiny which I attended yesterday night. It was the question of using the wrong reader. So that if you used your phone, and everybody has some of these phones sometimes, you came up with a different result. That was the fourth response to that particular issue of the barcode. And so the issue raised here is really a red herring as refers to that barcode. And fifthly, these were the same forms transmitted to the National Tallying Center and inspected by all parties prior to the declaration on the 11th. But to come back to the question your ladyship asks about the 6 ballot papers, it is indeed correct that the format of voting is that you're given all 6 votes and you walk into your booth and you take them. Now, the regulations, however, make provision for an item known as a stray ballot. There are many ballots that end up in the wrong ballot box. The regulations call them stray ballots. These are to be distinguished from a rejected ballot from a spoiled ballot. The same regulations require that the presidential election be counted fast. And so that by the time the results are being streamed onto our screens and being counted, all the other stray ballots have not yet been counted because they're in the other boxes.
Mr. Macharia.
Yes, Your Ladyship.
You're making the assumption that the voter votes for whatever candidate it is they want.
Yes.
And when putting, and that's an assumption.
Yes.
When putting their ballot box in their ballot papers in the box.
Yes.
For the candidate they have voted for.
Yes.
They would put all 6?
No.
That's the only way.
Yes.
A stray ballot would arise. A stray ballot is one.
Yes.
Which is put in the wrong box.
Correct.
So, even though it is correctly marked,
yes,
it is dropped in the wrong box.
Correct.
My question is this.
Yes.
Where a candidate, where a voter collects the 6 ballots.
Yes.
Because the assumption is we will be given all 6.
Yes, you're given all 6.
And you want to vote for only one candidate.
Yes.
Where do the other 5 ballot papers go? It's a very simple question.
That's what I answered, Your Ladyship. That the law, and I think the regulations actually make it quite clear, that even having been given the 6, and even with the color coding that the ballot boxes have, and the ballots themselves have, room is still created for what Your Ladyship correctly called the stray ballot, which is a correct ballot placed in the wrong box. Now, when you look at the regulations and you decide to do your ruling, you will find that those stray ballots are kept in a separate envelope by themselves according to the rules. Yes.
Mr. Macharia?
Yes, my lord.
You are still not answering the question.
Yes.
You walk into a polling booth.
Yes.
You're given 6 ballot papers.
Yes.
So you decide, as you may decide,
Yes.
that you'll only vote for a presidential candidate.
Correct.
That leaves you with 5.
Yes.
Those 5
Yes.
are not stray.
No.
They are unused.
Yes.
You've been given 6,
Yes.
but you have elected to use only 1.
Yes.
That leaves you with 5.
Yes.
What we are asking,
Yes.
where do those 5 go? How are they accounted for? It's a simple question.
Oh, yes.
They're not stray.
No, they're not stray.
They can only be stray if they have found themselves through in the wrong ballot box.
And that's the point.
Okay. So they're not stray. So you still remain with 5.
Yes.
Where do you put them? You carry them away?
No, 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 no.
How are they accounted for?
No, and that's the point I'm making. You vote. You vote for 1, and vote for the 2nd, and vote for the 3rd. You have 6. Let me explain again, as I understand the process.
Order, please.
I could allow one of my colleagues from IBC to do it, but I could. They are more conversant with that process, but yes, yes.
Please, my lords. The question that the court poses, my lord, the simple answer is this. There is a need, when you're given 6 ballot papers, you need to mark each and every one of those papers with your choice of the person that you're voting for. If, however, you elect to only vote for one person, the other ballot papers which do not indicate who you've chosen to vote for, if they are still put in the box at the point of counting, because you have not indicated who it is that you are voting for, becomes a rejected ballot. So that's a rejected ballot because it has not indicated who it is that you voted for. So among the rejected ballots, you will find the difference between the two. Because the purpose of a ballot is to indicate who you voted for. So if you don't indicate, it will most likely still be put in the ballot box. But since it will not have indicated who you voted for, it becomes a rejected ballot, not a stray one.
Very well. Okay, wind up, Mr.
And so, yes, my lord, and so that was the explanation for that one. The final point I think we wanted to make was a question raised there by our colleagues and brothers from the petitioners with the question of the votes for Nyando. That question, your ladyships and my lords, is dealt with in the affidavit of Winnie Gosho, and these were the 60,000 votes that my colleagues said were missed out of the Form 34C. The proviso to Regulation 87, Subregulation 4, entitles the second respondent, where the difference in votes not yet arrived does not make a difference, to still declare the result. The exact percentage of that vote from Nyando in Kisumu, Regulation 87. This is a proviso. This is the proviso to Regulation 87, Subregulation 4. The exact percentage difference that Nyando made, and it still counted, was 0.39% of that vote. And so this second respondent was entitled to do so. I end by calling your attention to an accusation made against the third respondent on the question of the President's delivery unit, or what's known as the delivery portal. Again, your ladyship and my lords, I call your attention to the affidavit of a gentleman known as Andrew Wakahio, signed and sworn in response to the affidavits of Dr. Nyangasi Oduwo and Olga Karani, and to paragraphs 100 to 120 or so of the affidavit of Winnie Gosho, and to the constitutional provisions set out therein as regards the duty of government to account and to deliver information to its people in a timely manner as to how it's spending their money and to what it is doing. Unless my lords and your leaderships have any further questions for us, we reiterate our plea to you to dismiss this petition and to do so with costs. Thank you very much.
Just a clarification. Both Mr. Ngatia and Mr. Ahmed Nasir, you described what we last watched on the screen as a video. For the record, I don't think that is the description. Perhaps you are gray-haired and perhaps not .com. Perhaps the .com member of your team can properly describe what is it that was presented for the record.
That was the offer the girl.
That was the graphical representation of the votes cast in all the positions that were sought for elections on the 8th of August. It was a graphical presentation.
And Lady, that's why I safely referred you to the affidavit of the third respondent.
Mr. Ngatia, Mr. Benassi, Mr. Omogeni raised one question yesterday about Section 23 of the Leadership and Integrity Act, and he asked the court to declare that section unconstitutional. Would you like to address us on that? Because we won't have another chance.
Yes. Number one, my lord, that is not a request in the petition. Nowhere in the petition would you find a request like that. Number two, being a contestation regarding an act of parliament, it ought to originate at the High Court. It can't originate from the bar at the Supreme Court. It is one of the matters that ought to be litigated under Article 165, and it should be done in the... So without any exchange of pleadings, Omogeni, with all respect, with all due respect, I think, was making a barb at it. It wasn't a serious request.
My Lord, can I just add one point that, I mean, a petition under Article 140 is a single subject issue. You are to determine whether the third respondent was validly elected or not. Unless, but my learned friend's reasons whether that Section 23 is unconstitutional or not really does not fall within the confines or the contours of this case. Thank you.
Okay, very well. We will adjourn and come back at... sorry? Yeah, Yes, Mr. Ranga.
Yes, my lords, when you made the order that judiciary staff be increased to undertake the process of scrutiny, we had a word with the registrar just outside, together with, in the presence of my other friends, Mr. Mwite and Mr. Karori. And he was telling us, yes, they have added staff, but now the challenge is that the agents, because the parties were restricted to 2 agents per party, by every party to this petition. So they cannot be able to execute that work as quickly as possible. And we thought that if the court could allow each party to have an extra 3 agents, then the work would go faster. In fact, from the registrar he was saying he could even upscale it to 200 members of staff of the judiciary to undertake that exercise. But I must say from the bar, since that time, there's been a lot of improvement in the work that is going on, at least from our perspective.
What is the view of the other parties? Increasing the representatives to speed up the work?
Lord, I will indicate that in a moment, but can I also clarify that as far as the access is concerned, that has been resolved and the petitioner has been given access, and I think that the registrar of this honorable court should be able to bring a report within the timelines that the court gave. Access has been given. So that leaves us only with the issue of forms 34As and forms 34B.
Yes.
And because of your lordship's directions that the staff be increased, the staff were increased, but now because of that increase in staff, perhaps the parties should be given the opportunity to be represented by slightly more agents. And I think
about how many?
Five as suggested is good. Your lordship also asked a question, her ladyship, the deputy president, on these unmarked. What happens to the 5 ballot papers if a voter decides to vote for only one candidate? And with your permission, I would wish my friend Karoli Kamau to perhaps draw the attention of the court to a regulation, section.
Yes, I think it's important to just show that even the regulations envisage the situation where a voter might not mark the paper. And Regulation 77, which deals with rejection of ballot papers, says that at the counting of votes at an election, any ballot paper, E, that is unmarked, shall subject to subregulation 2 be void and shall not be counted. So even the regulations envisage the possibility that a voter might not mark a ballot paper, and therefore that ballot paper shall be rejected and shall not be counted. So it actually envisages it.
Okay. Yes. Okay. By consent of all the parties, we will vary our order 4 to allow each party to have 5 representatives. Is that okay, Mr. Orengo?
Yes.
That's okay, Mr. Muite?
Yes, it is. I don't know about this.
To speed up the
third respondent, I don't know what the things are.
To speed up the process?
Yeah, we have no difficulty with that. It's good. It's fine.
That's fine. Okay, then we will adjourn for an hour. Come back at 3:30 and start with the interested party. You have 5 minutes. I thought, Mr. Kinyanjui, after lunch you can condense it to 5. Okay, 20 minutes. 20 minutes, and then we will proceed. Thank you.
Na mtazamaji, hapo ndo kukamilika kwa awamu ya kwanza na siku ya pili ya kusikilizwa kwa kesi hapa iliyowasilishwa na Raila Odinga ambaye alikuwa akiwania kiti cha urais kwa tiketi ya muungano wa NASA. Ni hapo mawakili wakiondoka tu na majaji pale baada ya kusikizwa kwa kesi hii kwa siku ya pili, na ni siku ambapo mtazamaji tumeweza kushuhudia mawakili kutoka tume ya IBC wakiweza kujibu baadhi ya madai yalikuwa yameibuliwa hapo jana pamoja na muungano wa NASA kuhusiana na uchaguzi wa Rais Uhuru Kenyatta. Jinsi unavyotizama pale ni mawakili tu wakiondoka baada ya kuweza kupumzika ama kupata pumziko la muda wa saa moja, na majaji hapa wameweza kupata fursa ya kuweza kupumzika hadi mwendo wa saa 9:30 ambapo watarejea tena ili kwamba waweze kuendeleza kesi hii. Kumbuka ni siku ya pili ya kusikizwa tu kwa kesi iliyowasilishwa hapa na Raila Odinga kuweza kupinga uchaguzi wa Rais Uhuru Kenyatta baada yake kutangazwa mshindi na mwenyekiti wa IBC Wafula Chebukati baada ya uchaguzi mkuu wa tarehe 8 mwezi Agosti. Na hii leo mtazamaji, tumeweza kushuhudia mawakili wa Rais Uhuru Kenyatta akiongozwa na Fred Ngatia pamoja na Abdel Nasir Mohamed pale wakiweza kuelezea tu mahakama kwamba ni madai tu ambayo yameletwe mbele yao, ni madai ambayo hayana msingi, ni madai yasokuwa na msimamo, ni madai yasokuwa na ushahidi wowote wa kudhibitisha. Kwa hivyo wao kwa muda mrefu sana waliweza kupewa takriban masaa 3 waweze kujadili kesi yao, anga kuweza kushawishi majaji kwamba amna kesi hapa, hayo tu ni porojo na mambo yasokuwa na msingi. Lakini itakuwa tu sasa itategemea majaji hao kuweza kusikiliza na kuamua kulingana na ushahidi ambao wameweza kupokea na kuweza kuamua mbivu na mbichi. Kumbuka baadhi ya masala ambayo muungano wa NASA ulikuwa umeibua jana ni kwamba kulikuwepo na tofauti kubwa sana ya kura katika wale walioweza kumpigia kura kiti cha urais na vile viti vingine kama vile kiti cha ugavana. Wao walidai kwamba kulikuwa na zaidi ama kati ya kura 400,000 na 500,000 ambao ni watu tu waliweza kujitokeza kupigia kura rais na hawakushiriki uchaguzi katika viti hivyo vingine 5. Kwa hivyo ni swala ambalo mawakili wa Uhuru Kenyatta walikuwa wakijaribu kudhihirisha na kuelezea mahakama kwamba kuna uwezekano kwamba kuna wao watu ambao waliweza kupigia tu rais kura na hawakuweza kupigia wale wengine. Kwa zaidi baadhi ya majaji walikuwa na maswali kwa mawakili kuweza kutaka kujua kwa kweli ile kura ilikuwa inahesabika vipi ama ilikuwa inatambulika vipi. Kwa hivyo wao walijaribu kuweka bayana kwamba kuna uwezekano kwamba kuna wale waliojitokeza kupiga kura ya urais na labda hawakuweza kupiga kura katika viti vingine hivyo 5. Kwa hivyo tu ni baadhi ya masuala ambayo yaliweza kujitokeza hii leo katika siku ya pili ya kuweza kusikilizwa kwa kesi hii. Alafu pia swala lingine ambalo liliweza kujitokeza ni kwamba wale mawakili wa Rais Uhuru Kenyatta waliweza kusema 99% ya wale maajenti wa muungano wa NASA waliweza kutia sahihi zao kwenye fomu 34A. Takriban ama 96% ya maajenti wao waliweza kutia sahihi kwa zile fomu 34A kuweza kudhibitisha kwamba hayo ndiyo matokeo ambayo yalikuwa katika eneo la kuweza kuhesabia kura. Na hivyo basi kulingana na wakili Fred Ngatia, 2% basi ambayo imesalia haina tofauti kubwa sana ikiweza kuzingatiwa kwamba Rais Uhuru Kenyatta alikuwa amempiku Raila Odinga kwa takriban kura 1.4. Kulingana na Fred Ngatia ilikuwa kwamba ile 2% ilikuwa ni dhaifu sana, kwamba haingeweza kuleta tofauti yote hata ikiwa ingepewa uzito. Kwa hivyo tu imekuwa tu muda wa kwanza ama sehemu ya kwanza, manake kikao cha leo kilianza mwendo wa saa 5 na mawakili wa Rais Uhuru Kenyatta waliweza kupewa takriban saa 3 waweze kujibu baadhi ya madai ambayo yalikuwa yameibuliwa katika stakabadhi na cheti cha kiapo ya muungano wa NASA. Na hapo katikati pia kidogo kuliweza kutokea ama kikao kiliweza kusitishwa kidogo baada ya James Orengo kuwasilisha malalamishi kwa majaji hawa wakisema kwamba ile shughuli ya kuweza kupiga darubini zile fomu 34A, 34B na cha yaliweza kusitishwa ama yaliweza kukumbwa na itilafu kidogo katika sehemu ya Milimani, katika mahakama ya Milimani. Na hilo swala lilijitokeza wakati ambapo Orengo alidai kwamba maafisa wa IBC hawajajitolea vizuri kuhakikisha kwamba shughuli hiyo inaenda katika njia ipasavyo, lakini majaji basi wakaamua kwamba maafisa wengine waweze kuongezwa katika shughuli hiyo ili waweze kuhakikisha kwamba shughuli yenyewe inaweza kukamilika kwa wakati ambao unafaa. Kumbuka ripoti hiyo ambayo itakuwa inawasilishwa na msajili wa mahakama itakuwa inatolewa mwendo wa saa 11 jioni, kwa hivyo inafaa kukamilishwa. Na shughuli yenyewe ilikuwa tu ni kudurusu zile stakabadhi ambazo zilikuwa zimewasilishwa na IBC, stakabadhi ambazo Raila Odinga amekuwa amewasilisha hapa, na pia IBC kujaribu kuuyanisha kuona kama kuna tofauti, kwa sababu msingi wa madai ya muungano wa NASA ni kwamba kulikuwepo na tofauti kubwa ama kulikuwepo na mabadiliko katika zile stakabadhi ambazo wanadai kwamba IBC iliweza kubadilisha kabla ya kuweza kuwasilisha katika mahakama ama kuweza kuwasilisha ili mahakama iweze kupiga darubini na kuweza kujua na kuweza kutoa mwelekeo. Lakini hadi kwa sasa tunasubiri tu muda wa saa 1 ambao wamesema kwamba watakuwa wanapata pumziko. Hiyo ina maana kwamba mwendo wa saa 9:30 majaji hawa watakuwa wanawasili hapa. Lakini kumbuka mtazamaji kwamba kikao cha leo kimeweza kushuhudia majaji wa 6, manake jaji mmoja anasemekana kwamba haisi vizuri, lakini wao wamekuwa wakifuatilia kwa karibu hapa kujua jinsi mambo yanavyochukua mwelekeo. Lakini mwendo wa saa 9:30 sasa tunatarajia wale wanajiita Friends of the Court, yani amicus curiae, kuweza kujitokeza na kuweza kuelezea mahakama mtazamo wao kuhusiana na swala hili zima. Kumbuka mtazamaji, pia kuna ile ripoti ya msajili wa mahakama ambayo inatarajiwa mwendo wa saa 11 jioni, na baada ya ripoti hiyo kutolewa, pande zote usiku watakuwa na uwezo, watakuwa na fursa ya kuweza kuipiga darubini, kuitazama na kuweza kujua na kutoa maoni yao, na kila upande wamepewa takriban dakika 10 peke yake waweze kutoa hisia zao kuhusiana na hiyo ripoti ambayo itakuwa inawasilishwa na msajili wa mahakama. Kumbuka vile vile mtazamaji, bado LSK hawajaweza kuwasilisha hoja zao. Tunatarajia pamoja na mkuu wa sheria hapa Githu Muigai pia atakuwa anawasilisha, alafu upande wa mwisho sasa itakuwa ni upande wa NASA kuweza kujibu masala haya kwa saa 1. Kwa hivyo swala zima huenda likahitimishwa hii leo ili kuweza kuwapa majaji hawa siku ya kesho na kesho kutwa ambayo ni Jumatano na Alhamisi kuweza kupiga darubini na kuona mwelekeo wao kabla siku ya Ijumaa ambapo ni siku ambao watatoa mwelekeo. Lakini kwa sasa narejesha kwenu studio kwa taarifa zetu za kimombo.
My fellow opposer talked of wearing her eyes. Maybe, and just maybe, these eye problems are as a result of air pollution. Yes, yes, yes. You talk of terrorism, and terrorism. Why is it that in the year 2004, our own late Professor Wangari Maathai. She got an opportunity to win the Nobel Prize. For what? For caring for the environment.
It is important that we acknowledge that global environmental degradation is a threat. That I cannot deny. But it is not the greatest threat. Citizens in countries like Somalia, South Sudan, Syria, and North Korea would beg to differ with me.
Good afternoon, welcome. This is Channel 1 Lunchtime News. It is the 29th of August, the year is 2017. This also marks the second day on the presidential petition hearing at the Supreme Court. We have a lot lined up for you, and we have reporters from across the country to give us other updates on matters happening across the country. But of course, we have a special comprehensive package for you on matters presidential petition, where we have our reporter John Jacob Curia will be telling us and painting us a picture of exactly what has happened today, bearing in mind it's the second day, and of course a lot is expected to happen, bearing in mind a deadline is fast approaching, with 5 o'clock expected that the NASA team will have managed to scrutinize forms at the Milimani IBC premises, that is forms that say 4A, B and the like. But of course now we first join our reporter John Jacob Curia to tell us exactly how things have been now. We can now join John Jacob Curia.
Thank you very much, Rose Gakur, back at the Broadcasting House. Indeed, once more this afternoon, we're coming to you live from the Supreme Court buildings here in Nairobi. And it has been quite a momentous occasion here, owing to the fact that the third respondent in the case was President Uhuru Kenyatta, and his lawyers have been making submissions from morning all the way through. And of course, before we get to the submissions, there was one more thing, obviously, that needed to be gotten off the road, and that was the compliance to the order given yesterday by the Supreme Court judges that the IEBC provides its logs, or rather read-only access to their servers. And the IEBC reported that, that it had not complied with that. In fact, the counsel for the petitioner, that is James Orengo, really bringing a report and filing a report that IEBC was yet to comply with a particular order, and Judge Maraga unequivocally stating that the IEBC didn't have a choice other than complying to that particular order given yesterday. Of course, there was the argument that the servers, are in Europe, and the time difference would have affected much more what was happening. But then again, the Chief Justice made it quite clear that the IBC didn't have a choice other than comply with that particular order, as by the time the court was taking a breather, and of course, from behind that, you saw James Orengo leaving the courts together with the lawyers representing NASA. But by the time the court was adjourning this afternoon, the NASA lead counsel, James Orengo, has reported there is good progress and they have been provided access to, including Paul Moite, the senior counsel representing the Independent Electoral and Boundaries Commission, and that there was compliance on their part. And that therefore means, again, there is a headway in terms of compliance for that particular order.
and therefore at 5:30, if the deadline, they will be able to meet, because there's also a scrutiny of forms 34A and B that is happening at the Milimani courts adjacently with this, access to servers. And if that gets to happen, then we're going to get the report by around 5:30. If it doesn't, then it just means we're going to keep vigil for some part of the night so that the report can be brought to the judges. And once that is done, then we will be able to discuss the content of that, or the council will have time to discuss the content of this particular report that will be filed by the registrar. But, Rose Gakuo, in terms of submissions made by the lawyers presenting President Uhuru Kenyatta, you're looking at Senior Counsel Ahmed Nasir Abdullahi and Senior Counsel Fred Ngatia. It was much more about the constitutionality or the law in terms of, invalidating an election, because the petitioner's prayer is that this election is invalidated. So what is the evidentiary threshold in terms of, invalidating, in terms of invalidating an election? And according to Ahmed Nasir Abdullah, he says it must be a transgression, by a voter. It must be a transgression felt by a voter. One, in terms of perhaps this petition ought to be filed by a voter, or number two, on that other end, it must be proven in this case that there was a voter, or there was a person who was not supposed to vote, or didn't have the rights to vote, but indeed did vote. So obviously saying that should be the threshold. And of course, what they have spent the whole afternoon, arguing is, on what evidentiary threshold one should invalidate an election, and saying the only anomalies found actually were about 872 votes that, if subtracted from Uhuru Kenyatta, it would subtract his votes or reduced by 974, and that therefore doesn't form a basis for invalidating the election. And of course, there was the other matter of, in terms of why is there a big gap in terms, or how do you explain the big gap in terms of the people who voted in these other elections, but then in the presidential election there's a higher number? And that, according to the IEBC, or in terms of how they explain it, and I'm talking about Wakili Kamau Karori explains it, that the people who choose to come to the polling center, and because there's no legal compelling that they must vote, or they must vote in a certain way, they decide to vote for the president or tick the ballot box for the president. Then they go deep in these other ballot papers into their respective boxes. But the question that Judge Philomena Mwilo and Smokin Wanjala were asking, in terms of law and practice by the Independent Electoral and Boundaries Commission, what do you call this ballot? And there was, a little bit of confusion when one of the lawyers decided to call it stray. But then, according to the understanding and in terms of the law, a stray ballot is where you have marked a ballot paper, but then instead of dipping it in the presidential ballot box, it is found within, it is found inside the box of the woman rep box, and issues like that. So again, they thought that it's a stray ballot gets dismissed, but then the IBC made it clear that it is called a rejected ballot. Therefore, once again, you're finding yourselves with the terms of rejected vis-a-vis spoiled ballot. Rose Gakuo.
John Jacob Carrier, do tell us, of course, there were indications earlier on that those representing the petitioner, that is the National Super Alliance at the Milimani law courts, were not able to access all the forms. Will this in any way probably jeopardize or interfere with what they think is the submission before the 7-bench judge member?
Well, of course, there was a little bit of confusion in terms of what was happening at the Milimani law courts and what was happening really in terms of access to servers. These are two separate issues, because these were the prayers that they made before the 7-judge bench. And of course, today you realize the bench is minus one judge. Judge Mohammed Ibrahim has been taken ill and therefore did not appear today. But the forms were provided by the IEBC, forms 34A and 34B, and the scrutiny is ongoing at the Milimani law courts. So the access to servers was what was contentious, because by the time James Orengo, the lead counsel, was coming to court, and was about 11, he reported that there was still non-compliance. There still was not compliance on the part of the IEBC in terms of complying with these orders to give them access. But like I said, by the time of adjourning Rose Gakuo, the counsel Paul Moite, as well as counsel James Orengo representing NASA, that is Orengo, and Moite representing IEBC, have reported that so far there's, they're making headway and there's compliance. So obviously that's a report we'll be waiting by the time it hits 5:30 this evening, Rose.
All right, and Kyria, maybe you could tell us that today it was expected equally, apart from the respondents who were expected to give their submissions, friends of the court were equally expected to do so. Do you think this is well on course, and will this be a success according to the projections given by close of business today?
Rose, kindly repeat that question. I didn't hear you clearly.
My question is, well, it is expected that the respondents were supposed to give their submissions today. Do you think this is going to be well on course to include everybody who was supposed to give their submissions today in terms of time frames?
Rose, the respondents are done in terms of responding to this particular case. There were only 3 respondents. That is the IEBC, its chairperson, and the third respondent, who is President Uhuru Kenyatta. The IEBC and its chairperson did respond yesterday. So the only respondent that was, remaining was President Uhuru Kenyatta, who is the third respondent. He has already wound up his submissions. So what we're waiting for after this, and after the judges come back, is about an hour and 20 minutes or so in terms of the submissions of an enjoined party, who is Professor Michael Wainaina, who is opposed to the petition by NASA. Professor Michael Wainaina is being represented by Harrison Kinyanjui, and they will take 20 minutes immediately after the court comes from adjournment. Then after that, there is the position of amicus curiae, or friend of the court, and the Attorney General, Professor Gideon Muigai, obviously is an amicus curiae after being admitted on Sunday by the judges, and then the Law Society of Kenya, that is LSK, but it's also going to, make its submissions. So when you look at the entire time, actually 20 times 3, that just takes an hour. It's only an hour. But then again, because of a constraint, perhaps of additional time and stuff like that, it could take 1 hour and 20 minutes. Otherwise, what you have remaining are not the respondents, rather, but an enjoined party as well as one enjoined party, because the other enjoined party was the Kuru Court, who made his submissions yesterday. The enjoined party right now is Professor Michael Wainaina, who is opposed to the petition, and then after that, then you have the friends of the court, or amicus curiae, and that is Attorney General Gideon Muigai, as well as the Law Society of Kenya.
All right, thank you so much, John Kyria. But just before I let you go, probably yesterday we did witness an incident where the security detail tried to have access but was denied. What is the situation like today? Are things calm? Is there anybody probably trying to gain access today? How is the security detail around the Supreme Court?
Today, the story was largely the same, if you would just point it out. So in terms of the security arrangement, because obviously for you to get through the gate, you must be grilled, and it must be proven that you have reason to come inside here. But then sometime before 1 o'clock, the NASA team was here. They actually got inside the precincts of Parliament, the precincts of the Supreme Court, and they were able to kneel somewhere on this ground and pray, because they have been insisting on prayer, and they were able to pray without interruptions. But then the problem came when they wanted to access the Supreme Court, because the officers insisted there was no space for them. There were about 7 MPs of the NASA coalition. They wanted to get in, but then they were denied access, and at some point there was a push and pull between both. It was not really quite dramatic, but at some point they asked that one of them is allowed in to go and check whether there was space, and indeed they were allowed. Junet Mohammed as well as Gladys Wanga got in to confirm whether there was space, and they came back with a report that there was space. When they got in, Rose Gaku, because it's the interesting part, they got in, they didn't even settle for a minute. They came out after that, even after space. So of course that one makes one question, what was the intention of all the melodrama that we saw outside this court? But again, this is politics, and you have to do it the way you can. Rose.
Well, many thanks to Don Jacob Kyria right there reporting to us from the Supreme Court, where the judges have taken a short break, after which they will be resuming that part of the hearing, bearing in mind this is the second day of the presidential petition, and we'll be certain to be giving you and painting you a picture as the hearing continues. Let's proceed. The Independent Electoral and Boundaries Commission has faulted claims that it has ring-fenced its server from scrutiny. The IEBC's lawyers in the ongoing presidential petition at the Supreme Court say the server is somewhere in Europe, and the Commission was undertaking some logistical arrangement to secure sensitive data before granting access to the logs.
There was a brief exchange at the Supreme Court this afternoon between legal teams of Raila Odinga and IBC of allegations that the orders issued granting access to servers used in the election were not being complied with.
There is substantial non-compliance, and we have written a letter to the court, and my lords, without taking a lot of time, a perusal of that letter will show that.
But counsel for IBC, Paul Mwite, told the court that the servers were situated somewhere in Europe, and due to time difference, there was that delay by the service providers in Europe, occasioning the concerns by NASA.
My lords, these servers are in Europe.
Sorry?
The servers are in Europe. We are not refusing to give access. Europe is a couple of hours behind us. We had to wait for them to start working. They have to set up the access window with safeguards. That exercise is going on, and I am instructed that that should be completed in the next 1 or 2 hours. So it's not us who are refusing to give access.
The Chief Justice David Maraga, however, maintained that the order deadlines ought to be adhered to, and that a report must be presented before the bench at 5 p.m. and any possible non-compliance will be treated as such unless otherwise proved beyond doubt.
I do not think is that this time there is any alarm. The registrar's learned counsel, Mr. Mwite, has said is in full charge of the process, and we anticipate by early afternoon that results would start being made available.
So there is no obstacle to complying with the court order?
No, none. None.
There is no obstacle with complying with the court order?
My written instructions and also through my telephone, there is no obstacle.
Yes.
And it's being done plainly in the presence of everybody. But there was a request for a facility beyond the order that was made, and that was turned down. If that is what is being called an obstacle, is to use the word obstacle wrongly. That was a request beyond the order, and that will be put in writing in the terms that I'll be able to present to the court.
The orders will be complied with. Yes.
Okay. Then Mr.
So the impression created that we are obstructing or not wanting to comply with the court orders.
Yes. Then Mr. Rengo, why are you interrupting our proceedings? No. I'm saying what they are saying, the court order is being followed to the letter. Why are you here?
No, my lord, that is not true. In regard to what my lord friend Mr. Paul Mwite has said, he's saying there's no non-compliance because the people in Europe are still asleep. My lord, you remember these orders were made when they were well awake yesterday. So the excuse of saying that the people in Europe are still asleep, I think is not justifiable.
It is for the parties and their agents to work out and comply with the order within the time specified by the court. At 5 o'clock, we want a report. Anybody who will not have complied with the court order will tell us why he has not complied, and we will determine whether or not failure to comply was reasonable.
The Supreme Court on Monday granted prayers to Raila Odinga to access the IBC servers to ascertain if indeed the results were transmitted from the servers in the August 8th presidential election.
And that is the legal action that continues. And of course, we'll be certain to be ensuring you're up to speed. But for now, we change the topic a little bit. And 10 people were killed and others injured when a Nairobi-bound bus collided head-on with a lorry ferrying building stones at a Bengal area, 60 kilometers from the on the opposite lane as a section of the road had been closed for repairs.
The Grizzly Road accident, which serious injuries, the bus lorry was on the wrong extensively damaged.
Mahali ambayo saa hiyo nime na OCS wasiliana na wale ambayo wanaweza kusaidia. Zote ndio
in 8 months taken to private hospital.
In the hospital, the wards are closed.
Traffic police. The areas in central Kenya of natural Kenya called
throes of a devastating drought that had further losses. The dry spell is expected to end with the onset of the short rain season expected
Indian Ocean Dive East Africa. It's also expected that the rainfall will be well distributed. Advise take advantage and
urban centers with a boost expected in hydroelectricity generation.
Water and sanitation, water resources in urban areas such as Nairobi, Nakuru, Mombasa, Garissa, Eldoret are expected to improve following the forecasted enhanced rainfall. The surface water runoff may
The prolonged drought that affected vegetation may later occasion mudslides when the rains come. Murang'a in central Kenya is one of the areas on high alert.
there is possibility of landslides in Murang'a and parts of Nyeri, for example. We are having an increase in lightning incidences in parts of Gatanga and also Mukoyo area of Murang'a town. And we are advising the residents to install lightning arresters.
The Ministry of Health has been asked to ensure sufficient supply of medicines in hospitals to prevent epidemics, including malaria. There is a 30% probability of El Nino rains occurring as a result of the positive Indian Ocean dipole. Judith Akolo, Channel 1 News.
Kenyans are opposed to any machinations by the newly elected members of parliament to increase their salaries even before taking oath of office. A cross-section of Kenyans says the legislators should instead prioritize the implementation of key infrastructural projects to make business better in the country.
A cross-section of Kenyans have protested a move by the members of the parliament to reject a pay structure by the Salaries and Remuneration Commission, slashing their salaries, terming the move greed of the highest order.
Kama ulichaguliwa na wananchi wakati kama ya 2017, natakana wewe utumie ile mshahara iko, kwa sababu tulisema Kenya hakuna harambee zinaendelea kufanywa. Kwa hivyo ile kitu iko toseka na ile mshahara unalipwa, kwa sababu hiyo mshahara hakuna mtu mwingine anasaidia. Pesa iko ya serikali ya kuendeleza kazi kwa wananchi. Kwa hivyo haina maana ukuje wewe useme uende ukapigane na hata uyaabiswa kusema tunataka muongezwe pesa. Hiyo ni tamaa. Kwa hivyo inatakana wewe uhudumie mwananchi na ile pesa ya serikali, kwa sababu hii wakati pesa itatoka ya kufanya kazi. Kwa hivyo usiwe na tamaa ya kusema.
Na mimi maoni yangu ni kidogo kwanza. I think before mtu aende kukuwa elected, he was aware that mshahara imefanya nini, imeshakatwa. Na huyu mtu mwenye ana demand sasa hii pesa anastahili kwanza anastahili awache kwa hiyo kitu, step down, mtu mwingine afanye nini, aweze kuwa elected. Na hizi pesa wanasema walitumia pesa kwa campaign, kupatia watu ama wanaenda kwa fundraising. I think he belong to jail, kwa sababu hakuna katiba inakubali labda mbunge aende kupeana pesa ovyo ovyo, kwa sababu si pesa imefanya nini, ameenda pale kuwakilisha wananchi.
Those sampled by Channel 1 are one of the view that MPs' salaries are still very high and the legislators be contented with the pay and the focus on serving the country.
Hii mambo ya mshahara ya wabunge, hiyo ni kitu haiwezekani, kwa sababu hawa watosheke na ile kitu wanapata pale, kwa sababu walichaguliwa na wananchi, waende wafanyie wananchi kazi, sio kuenda kuongezewa mshahara vile wanataka. Na hizo pesa kuna watu hawana kazi. Unakuta mahali tumesimama saa hizi, unaona vile watu wamejaa hapo situ, wanatafuta kazi na kazi haipatikani. Hao wamepata kazi, ile kazi wamepata wangefaa kushukuru, wahudumie wananchi vile inastahili.
They, however, want the MPs to respect the decision of SRC and help the nation bring down the ballooning wage bill. For Lunchtime News, I'm Kaltun Jama.
Governors have been warned against sacking county employees, saying that the county bosses should follow the law. While doing so, the Office of the Ombudsman, Chairperson Regina Mwatha, says sacking of county staff by governors is an abuse of office and will expose governors to unnecessary litigation, leading to huge legal costs that will be paid out of the public coffers.
We will give you the written document. Employees also know their rights, and what we are mostly guarding against also is that the employees who had a contract with the employer, that should they go to court and they are rewarded, then what they'll be rewarded will come from the taxpayers. That is what we want to avoid, so that then if there is any removal of a public officer, let it follow within the law. Let it follow the law, so that then the government and the county government is not actually paying a lot of money from people who may go to court. In some counties, we have heard the governors themselves say that about 400 people are going. In others, we have about 1,000. We need to prove this. If proven and these people go to court, then it means that they'll be paid for being removed from work, not in line with the contract that they had engaged.
And if you're just joining us now, this is Channel 1 Lunchtime News. We take a very short break, after which there's still many, or rather plenty of stories right here just for you. We take that short break now.
Vera Beauty College.
Vera Beauty and Fashion College, with branches in Nairobi, Eldoret, Nakuru and Meru, offers courses in fashion design and creative arts, beadwork and embroidery, interior soft furnishings, flower arrangement, entrepreneurship and many more. Register now and visit our website 0725 923 00706 Meru branch. 08087689. Star of Excellence. Star of Excellence.